Okay, so there were rumors that the native adoption case before the SCOTUS might be pushed to the end of the year, but I'm happy to say that we have a decision. The Supreme Court upheld the Indian Child Welfare Act of 1978, known as ICWA, in combined challenges known as Haaland v. Brackeen, argued in November of last year. You can see the full video that we just released a few days ago on the matter to fully understand what was at stake. Now, needless to say, I am thrilled, if not a little shocked, at the outcome. UNFTR! I'm thrilled because it wasn't a partial decision or full of half measures. It was a full dismissal of the complaint on every level that preserves the intent and the integrity of ICWA. It ensures that in all cases where there's an option for Native children to be fostered or adopted by Native families first, irrespective of relation, agencies are compelled to make this happen. Now, I'm a little shocked because of who joined in the decision. Only Alito and Thomas dissented, with Thomas writing the more detailed dissent. What surprised me, given the line of questioning pursued during the case, is where Kavanaugh landed. Roberts also concerned me with his line of questioning, and he too joined in the majority. And I had Barrett as a question mark, even though she seemed unmoved by the petitioner's arguments surrounding the constitutionality of ICWA and the nature of plenary powers. I wasn't sure whether she would strike an ideological posture given her personal history as a conservative Christian and an adoptive parent. I mean, she quite literally embodies the petitioning family in this case. In the end, it was Barrett who wound up writing the majority opinion and laying to waste every single argument made by the petitioners in this case. Here's the concluding statement of her opinion. Quote, "We affirm the judgment of the Court of Appeals regarding Congress's constitutional authority to enact ICWA. On the anti-commandeering claims, we reverse. On the equal protection and non-delegation claims, we vacate the judgment of the Court of Appeals and remand with instructions to dismiss for lack of jurisdiction. It is so ordered." This was a full rebuke of the claims, and now it's settled. The conservative think tank, the Goldwater Institute, threw the kitchen sink at this case, only to have it thrown right back at them. They tried to claim that Native children fell outside of the plenary powers of the Commerce Clause of the Constitution, and failed. They tried to make this a matter of race and not political identity by claiming that it violated the Equal Protection Clause. They argued in favor of states' rights, and lost. The court even threw out the interest of the states themselves due to lack of standing. So as far as I can tell, just perusing the decision for the first time, Barrett walks a few interesting lines. See, the petitioners were claiming that matters related to individual natives fell outside of congressional authority. And Barrett dismisses this, holding an old ruling that says, quote, "Commerce with the Indian tribes means commerce with the individuals composing those tribes." So Barrett is knocking out any states' rights claims. Fine. But she goes even further than that to say congressional authority has borders and therefore Congress doesn't have the authority over tribal affairs just in dealing with them as it relates to external matters involving the U.S. government. The equal protection argument went down in flames because the petitioners failed to prove that any party had standing to raise them. Basically, she left no wiggle room, as far as I can tell, for the dark money groups and the evangelical organizations to pursue additional claims. And that was one of my fears, that the court would rule on commerce-related issues but leave individual matters of adoption to some questionable threshold that left the door open for future states' rights challenges. Again, I'm only through one pass of the decision, but this seems like as decisive a decision as one could have hoped for. Now, I do want to recognize an absurdity that a good friend of the show named John Kane, a Native broadcaster and activist, makes sure that I include in any critique of a Native issue. And that's the fact that this was even a case in the U.S. legal system. You see, the very existence of this case and the fact that a different outcome could have impacted the future of Native adoptions is itself an affront to the notion of sovereignty. Again, the exercise that helps the most in understanding the absurdity would be to insert the name of another country in the place of a given tribal nation. Swap out Navajo for Germany as an example. On no planet would there even be a question whether the United States, or Texas for that matter, would have a say over adoption policies in Germany. But that's the absurdity of these matters. The idea that Native nations have to present themselves in non-Native courts to litigate tribal matters is in and of itself an affront to the nature of sovereignty. But in this decision, like I said, there's cause for rejoicing. It appears to not only protect ICWA, which is by every measure a success when it comes to the mental health and the well-being of Native children and families, but it protects future claims against sovereignty to the extent that this is now precedent. It's nice in this day and age to know that we can still be surprised by this particular court. So I'm going to take this victory and revel in it for today, because there's always another fight on the doorstep. Here endeth the victory lap.